First, as Christina mentioned, I am the District 1 representative to the NATA Government Affairs Committee. I'm also on the NATA Ethics Committee. I'm also Vice Chair of the Board of Allied Health in Massachusetts. And because of that, our lawyers tell me I have to tell you these things. I'm not a lawyer. Anything I say doesn't mean squat. It's my opinion. Take it for what it's worth. I have some insight from my experiences, but really what you're hearing is my thoughts and ideas on things. As a foundation, everything we do, whether you're walking around or practicing as an athletic trainer, is really structured by the rule of law in this country. And whether we like it or not, we have to consider those things every single day when we go to work and touch a patient. There are really three types of law that impact your profession. And the reason why this is important is because it's really hard to figure out. You all might have questions about whether an athletic trainer can do this or can do that, and those are valid. The problem is there's no one place to get the answer. And the system tells us it's your responsibility. So we have to have some understanding of these things. So statutory law, those are statutes within a society. They can be federal, they could be state. That's what the legislator passes. So when the House of Representatives pass a law, that becomes statute. The next level is executive branch rules or regulations. So within every government, there's the House of Representatives, and then there are the agencies. Department of Health, Board of Allied Health. That's executive branch, and they create regulations that you have to work under and understand. And then probably the most complicated part are things called case law. And this is what happens in the courts. So if there's a problem and someone sues you, and that lawsuit goes up and is seen by a judge, that judge's ruling becomes law for everything that comes after that. And that usually happens when there's some ambiguity in the law. Can an athletic trainer do this, or can't he? And if he does something, or she does something and causes harm, they could get sued. And if they get sued, and there's nothing in the law that specifically says if it's right or wrong, it goes to a judge. And that judge makes a ruling. And that ruling now becomes law for everything that comes after that. And there's absolutely no place in our system to track case law. You have to do these legal searches, and you have to read rulings, so it becomes complicated. Yet, you're responsible to know what they are when you practice every day. I apologize for this slide. It is the most goofy thing. This is you as a practicing athletic trainer. All of this are the laws and regulations that impact you every day. And if you think the slide is complicated, just imagine trying to figure this stuff out. So this is really a representative of what I just went through. On the top, the courts, state and federal courts. They rule, they create case law. The legislators, state and federal, they pass a law, it impacts you. They pass a law, it might impact a government agency, like the Board of Allied Health, or the Department of Health, or the Board of Pharmacy, or the FDA. And you work under all of those regulations. You also have to know what the laws are directly. And then ultimately, all of these rules and regulations impact your professional associations, because they create opinions on what we can do, or best practices documents. All of these things you are responsible for when you practice. So what's going on nationally? What are the trends? What are people doing that impact us every day? Well, the NATA is really responsible for kind of keeping an eye on things federally. And you may have heard last couple of years there are a couple of bills that the NATA has been pushing and asking you to support. Don't repeat this, but if you ask me, it's just a bunch of baloney. There's absolutely nothing of substance in any of the federal legislation that we're pushing. Right now, there's only one piece of legislation that the NATA is putting forward on our behalf. And it's actually not ours. We kind of latched on to other groups. And all it is to make sure that when you're traveling over borders, over state lines, if you're a physician or an athletic trainer, your liability insurance covers you when you're treating your athletes in another state. Typically, that was excluded. So if you're traveling with USA Soccer and you happen to have a game in San Antonio, and the team physician and the athletic director or athletic trainer are there, and they don't have a license in that state, their liability insurance wouldn't cover them. Seems ridiculous, and it is, but that's how state laws work. And this federal legislation is intended to make the insurance companies cover those things. Sure.
So for example, say that was a case in like an athlete tore his ACL or something.
Sure.
And they didn't like handle it properly, would they lose their license altogether?
Nothing's that simple. And we'll talk about that structure. Hold on to that question for a second. Last legislative session, the NATA had a second bill. They called it a bill. It was really just a resolution. And all it did was a statement by the legislator that they support the Secondary School Bill of Rights. Woohoo. Who wouldn't? It's a good thing. It just means athletes are going to be taken care of and it's going to be safe. Didn't pass a law, didn't impact us, didn't change anything, just as they support it. Remember we said that there are also these executive branch agencies that are out there. So at the federal level, things like the FDA, Food and Drug Administration, has all sorts of rules. FAA, think about this, travel. We travel as athletic trainers. Now more than ever, all sorts of rules. I mean, you can't bring a can of Tough Skin on an airplane. If you do, it's a federal offense. You can't bring a little thing of isopropyl alcohol. I don't know why you would, but if it's in your kit, it's a federal offense. So all of these little things impact us. Right now, or just after the first of the year, the Center for Medicaid and Medicare Services passed a rule that said in order to bill, prescribe, and use orthotics, you have to be a member of a licensed group or an accredited group. And it listed all of these rules and what that accrediting agency is. It's the Board of Orthotics and something or other, I don't know. But it didn't include us. So that means if it passes, becomes a rule, there's a federal law that says you can't put an orthotic in your athlete's shoe. You can't fit them, you can't order them. Certainly can't bill for them. So these are the types of things the NATA is responsible for overseeing and protecting us. On most of the slides, I have this little thing where I took that slide and I just highlighted the area of that big mess that we're talking about. So this is one of those government agency issues. So what's going on at the states? Remember that athletic training is a state-level regulation. What you can do here is different than what you can do in Rhode Island or Vermont or Oklahoma or anywhere. And it's your responsibility to know that. So when you graduate and you move to New Jersey, different rules. You can't assume what you did here works there. It's your responsibility to understand these. And in every one of these states, during every legislative session, there are bills that, if passed, impact us. It's constantly changing. It's a dynamic process. That's good, but it puts the responsibility on each and every athletic trainer to stay up to date. So what are some of the trends going on? Well, a big one in the last few years is deregulation. There is a trend in government, particularly with Republicans, to reduce the size of government, reduce the cost of government, and reduce the barriers to employment. While we think licensure is good, it also makes it harder to be an athletic trainer. That might not be good for everyone. From a Republican perspective, not that I want to get into politics, but the idea is to improve working people. Trump talks about it all the time. You do that by making it easier to work. So if we take away licensure requirements, hell, anyone can do it. Our neighbors in Rhode Island 2 years ago got caught up in a new governor coming in, within his first 100 days, passed a budget amendment which eliminated something like 40 boards and licenses, from barbers to eyebrow tweezers to who knows what. And athletic trainers were on that list. In effect, eliminating licensure. Not because they didn't like us, not because they thought we weren't valid, but because, put them on the list. So the Rhode Island Athletic Trainers Association had to scramble, prove that there's a reason why we should be regulated, and change someone's mind. And they did. And this is going on across the country. Sunset laws. Does anyone know what a sunrise law is? In many states, this isn't true in Massachusetts, but laws that allow for regulation, which is called sunrise, we're creating a regulation, almost always have sunsetting provisions. The law stands for 3 years or 7 years, and then it has to be renewed. So a sunrise law which established a board of athletic training and licensure in a state, they pass it, they're excited, woo, we're licensed. The sunset says in 7 years it goes away unless it's reaffirmed. So what happens during sunset is the state associations and others have to go before the legislature and prove that this should happen. That there's a reason to regulate. Our position usually is it's public safety. If any schmo can be an athletic trainer, that puts people at harm. Challenge is, there's no evidence to that. There are virtually no cases of an unlicensed athletic trainer causing permanent harm. Mostly because unlicensed people don't practice athletic training. It's also an opportunity for our opposition. Who might that be? Who might oppose us as a profession?
Physical therapist.
Anyone else? It's not just them.
Doctors.
Could be anyone. Anyone who perceives a threat or just doesn't like regulation. It's an opportunity for them to argue against us. And yes, physical therapy is a vocal opposition to us. So there are states that have had licensure for 20 years and all of a sudden they don't. Concussion laws, we know about this, they're constantly changing. I think there are 4 or 5 bills in Massachusetts legislature right now impacting it. So this is a really critical piece, and I'm afraid, and if you'll notice by the end, I'm a little bit cynical about some of these things, and certainly our profession at times. This was an incredible opportunity for a new area that we truly have a footprint in. We are experts in this area, to establish ourselves as leaders in concussions and concussion management. You do that by when a law or regulation is created, you embed yourself in language in a position of authority and power. You make it so the athletic trainer is prominently written and given the authority to make decisions. We were fortunate in Massachusetts. At the time this bill passed, we had a very good relationship with the Department of Public Health, who the legislature charged with developing these regulations. We sat with them, we wrote much of the legislation, we made it so we were a decision maker. That gives us legal authority. It gave a lot of people no legal authority. Physical therapy wasn't mentioned. Nurse practitioners weren't physician assistants weren't mentioned. There were 3 people, and we were one of the 3. In some states, we weren't paying attention. We weren't at the table. The regulations were written and either didn't mention athletic trainers or mention them in a subordinate position. Well, the athletic trainer can do this, but only under these circumstances. That weakens our legal position. And once something becomes law, it's really hard to change it. So right now in Massachusetts, for example, there are all of these people with different positions that weren't included, either trying to be included, or there are concerns about expanding. if you know the laws, you might realize that it's only MIAA schools that it applies to. We got private schools, we got middle schools, we got all sorts of different schools. Doesn't apply. People like physician assistants who weren't included. Well, I'm not to decide if they should be or not. I know why they weren't. I was at that meeting. But they want to be. So they've been fighting ever since to be a decision maker. The other challenge with these, and again, here's where I'm a little bit cynical about ourselves. You'd be surprised how many athletic trainers don't want the responsibility or don't take it. I don't know how many athletic trainers I talked to who said, I work at a high school. I'm not going to decide if he can go back in. I send him out to get a doctor's signature. And that erodes our authority. It erodes our knowledge base. It erodes our power because we're fearful. You have the education. We put ourselves out as experts. We don't take that responsibility. We're only hurting ourselves and our profession. Insurance reimbursement. Constant change. We get Obamacare, moving towards Trump care, I guess. I don't know. Constantly changing. Insurance companies, constantly changing rules. Always, always, always there's legislation actively going on that impact third-party reimbursement. Who gets reimbursed? How much they get reimbursed. Our neighbors to the north, Vermont, is a really progressive. They've had third-party reimbursement forever. They bill. They work in hospitals. They work in clinics. They bill for the services. They get reimbursed. They have more jobs in the state for athletic trainers now than before that because where money comes, job comes. If you can earn your keep, you're going to get hired. They have a bill right now that's taking what's already a really strong reimbursement situation to the next level. The problem with Vermont was when they passed the bills, the language read that athletic trainers have to work in clinics owned and or operated by physicians and physical therapists, because that's all there were at the time. So if you work in those facilities, you can reimburse just like a physical therapist can, which is great. But in hindsight, what they realized was that means they can't own their own clinic, because they have to be working with and for a physical therapy or physician-owned clinic. So their legislation is taking it to the pinnacle, giving them the authority to own their own clinic. I already mentioned opposition. It's always going on. So what's been going on in Massachusetts? So yeah, last night I just did a quick search of all of the bills. Anyone can do it. You can go online. There's a bill search thing on the Mass website. You type in athletic training, in quotes, athletic trainer, in quotes, and it will give you a list of every bill that language appears in. Some are ours, meaning athletic trainers of Mass have put these forward. Others are not. So, enact to promote consumer choice in healthcare. This is a bill that's sponsored by the Athletic Trainers of Massachusetts. It's been around for 20 years. I wrote it when I was president of ADAM in 1998. These things take forever. And really, it's an anti-discrimination bill. All it says, it's a paragraph. It says that an insurance company can't discriminate against an appropriate licensed profession practicing within their scope of care, scope of practice. Why has it come to this? Well, for 20 years, we sat down with insurance companies and said, we're smart, we're well educated, we're good at what we do, there's value in what we do, you should reimburse us. What's the job of an insurance company? Make money. How do they make money?
Accidents.
That's how they lose money. You get a payout for an accident.
Deductibles, like claims.
So, all good things. Deductibles. What's a deductible?
The money that you have to pay at pocket.
A way for them to reduce how much they have to pay. You pay first. Insurance is a really simple industry. Take in money from premiums and pay out money from claims. If the take-in is more than the payout, they win. Everything an insurance company does is intended to do one of two things: attract more premiums and reduce the amount of payout. And unfortunately, unless there's a law that says they can't do something, they can do it. And their position has always been, we're just not paying athletic trainers. No matter how much we say we have value, and unless the people that are paying the premiums demand that they want it, they have no incentive to pay it. So when you get to the point where they're not listening, the only thing to do is pass a law that says they can't say no. And that's what this bill is intended to do. House bill, and keep in mind these numbers change frequently, so they might not be exactly right in any given moment, but enact relative to the practice of athletic training. So you'll see in a few minutes our practice, the laws around our practice, what's good and bad about it. These two go together. While they're independent and they work fine by themselves, it's a package deal to improve our practice environment. Reduce restrictions on what we can do, at the same time allow us to generate revenue, bill for services. But there are a whole slew of other things. There's a bill about student safety and inter-school athletic activities. It's related to concussions, changing the rules, emergency action plans, requiring them. An act to protect sports medicine professionals. This is the exact same law that the NATA is spending tens of thousands of dollars to do at the federal